this city. And we were talking that historical monuments are to be protected just like themselves, like the phenomena of culture. The other round table is this round table that is dedicated to legal aspects of exhibition activities and cultural heritage protection. It reads international, but as experience shows, we have similar support for exhibitions taking place in this country. We need legal protection, insurance, and all other things. Exhibition topic is similar important as the monuments. And 2 days ago, my Austrian counterparts told me that the sharing of cultural objects between Austria and Czech Republic was stopped. Because some of the objects were seized by the claim of Ronald Rauder, who believed, and the court didn't decide everything, but still, he's a millionaire, he's a collectioner, and only on that ground the Czech paintings were seized and are in bonded warehouse now. That's a classical example of some deteriorations that may take place and what we are afraid of. There's another example that is that was voiced at the plenary session yesterday. That's the American Hasidism story with Schneerson library. There is the judgment of the American court that it is to be transferred to the American Hasidism. And there is a danger that based on such cases, some Russian property abroad can be seized. So for 2 years in a row, there have been no cultural loans to the United States because we do not have guarantees that nothing will happen. And I understand the vessel Sidov didn't sail to the United States because it's commonly subject to such threats. But speaking of protection, that's a classical immunity from seizure. And later on, I'll try to tell you how the museum community, through their effort for many years, we gave birth to some legislation that supports that kind of protection. And yesterday, I had a chance to thank the Lord Chancellor, Minister of Justice of the United Kingdom, because that country finally passed a law to guarantee the return of paintings despite any claims. We should also keep in mind that the problem is even broader. Museums are being sued by former owners, by some states and nations who were losers in the war. Church, religious organizations raised claims, and cultural donor organizations from which territories some cultural objects had been withdrawn. That's the broadest problem, and it's next to impossible to have it resolved, but the guarantee of return may keep exhibitions going, keep them mobile, and globalization is a good thing, but there is a serious threat, and private collectioners sometimes do not contribute, refuse to contribute their pieces of art to be displayed. Speaking of our time frame, I encourage you to speak for not longer than 10 minutes. And with that, I'm turning the floor to Mr. Van Woudenberg-Noot, who I think will tell us about his book. And I think he is the key expert on state immunity and cultural objects on loan. So you're welcome.
Is it possible to show my PowerPoint on the screen as well? Great, thank you. Well, thank you very much, Mr. Petrovsky, for this introduction. The next 10 minutes I'm going to speak about immunity from seizure for cultural objects on loan. It will be a general presentation. After that, and when we come into the questions and discussion round, I can tell more on the Austrian-Czech case. I can say a little bit more about the US policy and the legislation in regard to immunity from seizure and the efforts to get loans pending again. And as I'm legal counsel in the Netherlands, I can tell you a bit more about the Dutch situation as well. But now this 10 minutes will be a general presentation on, and may I get the next slide, please? Is it, or can I do it like this maybe? Yes. I'm going to speak on the regard to the question, are cultural objects belonging to foreign states while immune to another state immune from seizure on the basis of customary international law? Because it is safe to say that borrowing and lending cultural objects is not a new phenomenon. And until recently, nobody seemed to worry that an individual or a company might think of seizing an artwork. Consequently, there were no concerns about immunity from seizure. But meanwhile, immunity from seizure for traveling cultural objects has become more and more a concern for states and museums. And this is mainly due to an increasing number of legal disputes over the ownership of cultural objects, particularly as a result of claims made by heirs to those objects expropriated by communist regimes in Eastern Europe, as well as Holocaust-related claims. And it occurred to me when I was investigating this issue that it was not clear whether states and museums actually knew what the current state of affairs was with regard to immunity from seizure of cultural objects belonging to foreign states and on loan abroad. So my definition of immunity from seizure during this presentation is the legal guarantee that cultural objects on temporary loan from another state will be protected against any form of seizure during the loan period, and that definition had been used in an EU action plan. In 2004, the Convention on Jurisdictional Immunities of States and Their Property had been established under auspices of the United Nations, addressing, among other things, immunity for cultural state property on loan. That convention, however, has not yet entered into force. And I thus considered it necessary to investigate whether another rule of international law was already applicable, meaning a rule of customary international law. Because a rule of customary international law is binding upon states without necessarily becoming a party to a convention. And so I did. I investigated whether a rule of customary international law already exists, to the effect that cultural objects belonging to foreign states are immune from seizure while on loan to another state for a temporary exhibition. And if such a rule exists, is it emerging? And if such a rule does not exist, what are its limitations? In the autumn of 2011, I finalized my study, and it's my aim that this study can provide more clarity and legal certainty in the field of lending and borrowing cultural state property. I used a wide range of sources. Not only did I examine the relevant treaty law and literature, but I also assessed relevant case law. I looked into national legislation on state immunity and immunity for cultural objects. and I tried to discover what states brought to enact that kind of legislation. I also investigated how states acted during the debates of the International Law Commission, and that specifically regarded the part on immunity from seizure in the aforementioned 2004 UN Convention. And I followed the oral observations within the European Union on the Mobility of Collections Working Group. Finally, I visited several cities and states for my investigation, and I have been in the Russian Federation as well, where I have been received in a very hospitable way by the State Hermitage Museum here in St. Petersburg. So, what did I conclude from all these investigations? First of all, it occurred to me that in recent years there is a growing state practice pointing towards protection against seizure of cultural objects and loan and belonging to foreign states. Many states consider objects belonging to foreign states and on temporary loan in use for government non-commercial purposes, and for that reason already immune from seizure. And the background of that is that these cultural objects are sometimes referred to as goodwill ambassadors. They help understand the country, the culture of the country, the history of the country, the people of the country, and for that reason they are often considered as sovereign, non-commercial objects, and for that reason are considered to be immune from seizure under international law. States sometimes count on a general rule of customary international law in regard to immunity for state property, and sometimes even also count on the existence of a specific rule of international law immunizing cultural state property on loan. And with regard to such specific rule, I come to the conclusion that indeed a relatively young rule of customary international law exists, although not yet firmly established or well defined in all its aspects, stating that cultural objects belonging to foreign states and on temporary loan are immune from seizure while on exhibition abroad. The rule only applies to cultural objects in use or intended for use by the state for non-commercial purposes, and the objects, for instance, should not be auctioned. And I would say that the rule not only applies for cultural objects owned by a state, but also in the possession or under the control of a state. However, it became clear to me that although states want to immunize cultural objects on loan, they also want to prevent and to combat illicit acquisition or unlawful removal of cultural objects, such as the plunder of cultural objects. And they strive then for the return to the state of origin, because one should keep in mind that in order to be considered as a rule of customary international law, a rule needs to be based, among other things, on a widespread, representative and virtual uniform practice of states and of opinio juris. So that means that it's not necessary that the state practice is completely uniform, but all the states or most states involved in the actual lending and borrowing of cultural objects should be involved. And with some categories of cultural property, this widespread, virtually uniform acceptance is absent, and that first and foremost considers cultural objects plundered during armed conflict. And that's also what you see now in the United States. Maybe we can talk a little bit later on that. At the moment, also because of what all happened with the discussions on loans from the Russian Federation to the United States, currently in the American Senate there is a law which should give a better understanding of what is the relationship between the Immunity from Seizure Act, on the basis of which cultural objects are immune from seizure in the United States, and the Foreign Sovereign Immunity Act, on the basis which states have immunity, but also sometimes do not have immunity. And according to this law, cultural objects on loan are immune from seizure, unless it regards Holocaust confiscated art. So that's basically a little bit in line with the general conclusion of my investigation. The other category of cultural objects which would not fall under this customary international law rule would be objects which should be returned under one of those three conventions. Of course, this only applies if the state is a party to this convention. Again, because states sometimes act differently. Some states says immunity from seizure prevails. Other states says these international legal instruments prevails. And because there is not a uniform practice, which is necessary for a rule of customary international law, the rule of customary international law that I just described would not apply to categories which would fall under these conventions. With that, I come to the end of this presentation. As I said, if there are questions or discussions, I would be very much likely to go more into the situation in the Netherlands. I would like to go more into the discussion in America, or in regard to the situation of the confiscation of Czech cultural objects in Austria, which actually also had been lifted because both the Austrian and the Czech Republic said these objects cannot be seized because that is a rule of customary international law. And for that reason, the higher court in Austria had to actually to order that the seizure should be lifted, and that happened. All this, and that's my final word, is also, again, is also described in my book. Mr. Petrovsky, as the Hermitage also was so helpful in my investigation, I really would like to present you a copy of this book. Thank you very much for having me here. It's the Chile. It is already back in the Leopold Museum in Vienna. It had been in custody in the United States for 12 years, but in the end, the Leopold Museum and the Bandy heirs came to an amicable settlement, which meant that the Leopold Museum had to pay $19 million. And now in the museum there is a sign which describes the history of the painting, but it's back in the Leopold Museum in Vienna again.
Well, I suggest that we can listen to all the presentations here and then ask questions and perhaps have a general discussion of the various situations and cases that emerged around this subject. So we are talking about this protection measure of immunity, then we will be talking about insurance. I give the floor to Jean-Christophe Barbato for his presentation. Thank you. Thank you very much, Mr. Chairman. First of all, I would like to say that I would like to thank the organizers of this international forum, and it is an honor for me to speak in front of such authoritative figures as the director of the Hermitage Museum. First of all, I would like to talk about the French law, what the French law provides to the protection of the objects of art and culture. What are the immunities available under this regime, and what is the framework for such work? I should say that art is our public property. It's according to the Saint-Germain verdict of 1749, it is inalienable property which cannot be confiscated. Indeed, we're talking about a procedure of declassifying, the so-called declassification procedure of art. That's the only time when some art was confiscated or was taken out of public property. And the only case that I remember is some art that was previously taken from the tomb of Venus. Well, we're talking about immunity and the inability to seize any property that was on loan to the French museums. For two reasons. We're talking about some European Union norms. The art which circulates in the European Union is subject to the free movement of goods and also cultural objects. A work of art, since it is also sometimes the object of monetary transactions. In this sense, this is also covered by the norms of the free movement of goods. And this means the non-discrimination clauses that would be in force towards the collections of art, including those that are on loan to another European Union member. You need to treat such collections in a similar way as the French collections proper in the French territory. Well, I'm not sure whether the International Court would have a different opinion about this, but I think that there should be some adjustment in the French legislation, because this law covers also collections that come from other countries. Either France would abandon its rules, which is quite difficult to imagine, or France would provide the same protection or immunity to the collections coming from other countries. Now, this might be the first option that we may take in legal disputes, and we can also guarantee reciprocity in terms of immunity for such property, and this would not only relate to the European Union but to the whole of the Eurozone, and they are talking about some real protection which is available within this European space. Another option for the European Union is more positive. We need probably positive measures that would support the movement of museum collections and collections of art and objects of art and culture that are included in such collections. In the early 2000s, 2006, I think, a plan of action was adopted in this area, and an expert working group was established as part of the WTO efforts. And the direction that was taken by the European Commission is quite strange. You have some quite strange logic of disseminating best practices. You need to promote states to adopt legislation that would institute the inability to confiscate the collections of art. Undoubtedly, all countries need to have similar norms about immunity, and the fact that we can extend the protection coverage to the collections of other countries, but at the same time knowing that, as the members of the expert working group stressed, we may also run into challenges of protecting intellectual property rights, and also into challenges with the bona fide and good legal practices. So far, we don't have any specifics on that. That's why many people are asking why this work has not begun yet. Well, there are other means in the European Union. There is a cultural section, and I would say we're still talking about some pinpointed efforts, not any general coverage. But the European Union can also act on the basis of its directives, norms and rules, and thus adjust the law by providing freedom of transfer and transformation of collections. So far, we, as I said, don't have any specific action taken here to regulate the lending and borrowing of museum collections. I don't think that the European Union is acting to the best of its capacity and capability. In the cultural area, I should say that we still need a lot of adjustments to be made, and they are quite feasible and would be prompted by the logic of our development. However, we are not intensive in our efforts, and this, of course, would not help to resolve the existing challenges. The pace is quite good, but still we want to see a new directive of the European Union that would harmonize the efforts of all member states to provide for the immunity of all collections of art. Apart from other measures, all countries have their own pieces of legislation, but we don't have the same equal treatment. We are not talking about a distinction between private and government collections, and there is too little interaction and trust, mutual trust between the countries, and that's why this policy is not working well. I think you raised quite a few interesting issues, and we do have some experience in communicating with France. And actually, I never was in a Russian court, but in France, I was actually summoned to court, to the Supreme Court of France, which was related to the case of Matisse paintings that were claimed to be seized. And I recall this situation, and the French state actually supported the sovereignty of Russia on that collection and supported Russia's claims. And now we know a different approach by the U.S. courts, but I think that we need to probably comprehend this. Indeed, the cultural value and the museum community acted quite intensively. And I think that the museum community is more active, I think, in France than elsewhere. I'm not really well versed in legal matters, but I think that cultural goals of a state are no less important than other legal areas or areas of law. I would like to give the floor now to Anna Dost from Trott to Zoltz Lamek. We will be discussing restitution rates. Well, thank you very much.
Thank you very much, especially for inviting me to this roundtable. I feel very honored. And I just start perhaps with the exception to the general rule as addressed by Mr. van Woudenberg. After a short introduction, I will just very briefly refer to the Russian law, which is probably familiar to many here in the room, and on the Washington principles of Nazi confiscated art, before moving to the German law aspect and the one case where actually an art object was seized in Germany in the early 90s, and then come to the current legal situation in Germany, which actually protects art objects on loan. As you all are aware, here in Russia, and in particular in St. Petersburg, there was unprecedented Nazi loot, not only throughout Western Europe, but also in the Soviet Union, and whereas it was in the Western parts more about plundering, it was the Nazi, as you know, the Nazi ideology was about destroying so-called Slavic art. And after the war, Soviet troops found art in Germany and took it back as compensation and trophy. And as under these trophy artworks, there were also some which had been plundered before by the Nazis throughout Western Europe, such as the infamous Einsatzstab Reichsleiter Rosenberg in the Netherlands and France and Belgium, for example. In the late 90s, in 1998 exactly, there was a federal law in the Russian Federation adopted which deals with these matters, and it has the main purpose of course, defending the said cultural treasures and protecting the interests of the Russian Federation vis-à-vis foreign states, and really relies on the principle of reciprocity of exchange. And after a decision from the Russian Federal Constitution Court in 1999, in the year 2000, there was an exception to the general rule amended into this law, which grants the Nazi victims whose cultural objects are still in Russian collections now the right to claim these objects, alas, via the foreign ministries, which means if, for example, you have a British citizen who has a painting in one of the Russian collections, he has to turn to his foreign ministry, and the foreign ministry of the United Kingdom will then turn to the Russian foreign ministry to deal with this matter. The Russian Federation was also part of the 1998 Washington Conference on Nazi-looted art, and also agreed to these main principles adopted there, which means that art identified and stolen by the Nazis should be published, and a just and fair solution that these are the main lines should be sought with the heirs claiming art. However, the Russian law was not amended. It's still in this version after the inclusion of the principles after the decision of the Russian Federal Constitution Courts. And so, unlike in other countries, for example in France or the Netherlands, where there is such a procedure, heirs claiming, mostly Jewish heirs, cannot turn to the Russian museum directly, but have to take the aforementioned procedure via the foreign ministries. I will now come to the main question of this panel, the question of immunity of seizure with regard to Germany. And there was one famous case in the 1990s where actually the Knight of Liechtenstein, Hans Adam II, filed and had confiscated at first an art object, a painting from Peter van Leer, seen in front of a Roman lime kiln, which had been nationalized in the 1940s in the Czech Republics under the Beneš decrees, and then sent from the Brunner Museum to Cologne to the Richard Wallraff Museum. And he had first confiscated it, but then lost his lawsuit through all German courts up to the German Federal Constitution Courts. And when he filed a motion before the European Court of Human Rights, this motion finally was also dismissed in 2001 because all argued that Germany has to respect his obligations under international law, which means that the city of Brno received the painting back eventually. Now, as my last point, as my second to last point, I just want to make clear that there were already the nobles or the aristocrats who had their property seized in the 1920s after the Russian or the October Revolution, tried to file lawsuits in then Weimar Germany in 1928 when the Soviet states sold part of its collections. And also in 1928, they lost their cases before German courts. Until now, there is no legal procedure known in which a German private or legal entity has ordered the seizure of Russian artworks exhibited in Germany so far. And the Liechtenstein case showed that the German and the European courts had respect for Germany's obligations under public international law. And finally now, a German Act of Protection of Cultural Assets had been adopted in 1998, and it endorses the principle of safe conduct of cultural values as it implements it in Section 20 of this German Act of Protection of Cultural Assets, which means that lenders of foreign cultural items who lend their items to temporary expositions may turn to the German responsible office and obtain so-called legally binding warranty of return. And this warranty, once issued, cannot be withdrawn. And this warranty has the legal effect that third persons cannot file for any claims against the vindication of the lender before German courts, according to paragraph 3 of this section 20 of the law, which means that all claims for confiscation or seizures and arrest are inadmissible before German courts according to this law. And therefore, I would conclude that Russian museums should be pretty much on the safe side with sending their artwork to Germany, even with regard to so-called trophy or even Nazi-looted art. Thank you very much for your attention.
Большое. Два только соображения. Первое.
Thank you very much for your considerations. I fully agree with them. And when it is about cultural values looted by Nazis from Jewish families and during the Holocaust, there is sometimes confusion, and in the media it's always the case that objects kept in Russian museum belong to that category. But actually there are very few objects in the Russian museum belong to the Nazi looted values. I can think of just one or two objects like that. Secondly, I was really pleased to hear that there is no threat, but we know that together with our German counterparts we organize exhibitions and displays, but they take place locally. We do not bring them to Germany. Now I can see that they can travel to Germany as well. However, it's up to the Ministry of Culture to decide. But really, I'm pleased to hear that from the legal standpoint, there is every ground not to be afraid of that. So, dear colleagues, protection of exhibitions, legal protections from those who are really striving to seize them. Another kind of protection is insurance. You can even insure from seizure, and at some point our UK counterparts suggested that those objects would be insured in case of seizure. However, we didn't dare doing that, but looks like according to the English law it's quite feasible. I think that the chief method is insurance. It's the universal method, and I would like you to hear from our leading insurance companies. So first comes Ingolstadt insurance firm, and I'm turning the floor to Mr. Hrabrich, who represents Ingolstadt insurance firm in St. Petersburg. Good afternoon, ladies and gentlemen. Thank you very much for the opportunity to speak here and represent the insurance community at this round table. To begin with, I would like to congratulate you all. It's the International Day of Museums, so I would like to congratulate all museum community on that holiday, and I wish we could develop better understanding, better interaction between us, because we understand that the closer the museum communities are, the better we can keep the heritage of the past, and it will strengthen our spiritual foundation for the brighter future. And also, I would like to wish us have better understanding on the part of the governmental agencies, so that they would be supportive of the museum activities. And coming back to the topic of the round table and speaking of the protection of historical and cultural values, we think that the main thing here is an insurance policy or the insurance contract. Today, in 99% of the insurance of cultural values, we speak about classical ways of insurance, from stealing, from third parties, natural disasters. And at the same time, there is always a possibility that in some case arises that is not prescribed, that is not stipulated in the contract. We can speak of that case with the Schneerson Library, and that because it was not stipulated in the insurance contract and it was not recognized as the insurance case. It's subject of discussion whether it is possible to insure that. However, as the insurance company, we are eager to insure against such a risk, and in terms of mathematics, we don't see any problem to calculate the specific rate in case something is seized. However, there's a stumbling block here, and it's an open secret. Being the direct insurance, there are some reinsurance companies and which treat non-typical, non-standard ways of insurance negatively. And it means that whether we will have to cover all those cases ourselves, and it's not beneficial to us, or risks will stay. In order to prevent such risks and minimize any damage from them, we certainly need some support from the government and governmental or state regulation. The state in the area of insurance has already made great progress in this country. It's promoting the insurance through the mandatory insurance 15 years ago, and we were only at the beginning, but third-party responsibility in car industry boosted the insurance practices, and mandatory insurance was promoted, and it triggered also the voluntary types of insurance. So the role of the government is quite sizable here. Speaking of the protection of exhibition projects of cultural values, we can see two instruments in place. The one was voiced recently by Vladimir Putin, and it has to do with the export insurance agency, and so that some functions can be delegated to that agency. And there is another instrument that is well developed abroad, that's state guarantees, and there are some distinctions about that, and for that I would like to turn the floor to our expert in cultural values insurance. It's Mirko Modrinic, and he's fully in the picture of all those initiatives, so he will explain those subtleties and between various ways of insurance, and he'll give you more details about state guarantees that we would like to have in place in this country. Good afternoon, ladies and gentlemen. Thank you for the opportunity to speak here. And I will also congratulate you on the Day of Museums here. and fully realizing the importance of insurance companies' participation in ensuring heritage objects. We all have always trying to establish long-term relations of confidence with museums and the Ministry of Culture. The primary objective of the insurance is the optimization of financial costs and minimizing respective items of the federal budgets. It's an open secret that most of the museums are financed by the state, and that those funds are quite negligible. And main advantage of cooperation with insurance companies in state exhibition projects is the reliable reinsurance protection with the museum. And Ingostrach, in particular, the biggest in the Russian market, enables to accumulate the bulk of money inside the country and thus reduce costs for insurance. Speaking of the cultural values insurance, I would say that insurance companies have no restrictions or limitations now in that market. Currently, all insurance companies who have FRIGHT license may insure museum objects, cultural values, and museum objects are not just freight, and it's not cargo, we understand that, and so it has its specificity. It is true that at this point there are some leaders in the insurance market. It's Alpha Strachovania firm and Ingostrach firm, my firm. So I can speak on behalf of the two companies, I dare say, and I think we're the ultimate leaders in the area. So today, in my company, we have developed specific rules for ensuring cultural values, covering all the specificities. Normal cargo insurance rules do not enable us to minimize the costs. In 2001, there was an incident with one of the Russian museum in Houston of the USA. A painting was damaged. I'm not specifying which museum was that, but the bulk of the insurance premium was paid not only for restoration, but for the reduction of that cost, of that value. Normally, insurance practices do not cover for that. And we need to understand that given the value of museum exhibits, reinsurers are mostly linked to such projects as reinsuring. Currently, the Ministry of Culture has set a working group including leading insurance people, so they discussed insurance issues. So the outcome was that single rules and requirements for cultural values insurance were drafted. So currently all companies can be guided by them. One of the main aspects, or some aspects of those rules, I'm going to briefly tell you about them. It's the reinsurance of risk in some ratio. It's facultative reinsurance of risks. That's the presence of the rules for reinsurance. But there are so many details. It will take us hours to discuss that. I can only say that insurance people, as the museum community, are concerned with the insurance practices on the basis of Federal Law 9.4 on procurement, which does not allow governmental agencies to do insurance without tender. So currently, state institutions should not make a choice, should favor. And it's not only about insurance. So currently, state bodies have to choose not from the best participant of the tender, but in favor of the cheapest bid. So according to Federal Law 9.4, we can see that any company, perhaps which has never insured cultural values before, can participate in the tender, offer the cheapest bid, and win the tender. In such, and those are frequent cases, and it so happens that museums become most vulnerable because of that. And despite of those tenders, it is the cheapest company that wins the tender, and the museum has to sign an insurance contract with that company. I think that concludes my remarks. And speaking of the state guarantees, we think that it's one of the most meaningful and powerful instruments to promote the museum activities both in this country and abroad. I think we should better learn from our foreign counterparts' experiences, who have been using that state guarantees instrument for many years. But last year I attended a meeting in the Ministry of Finance here in Russia, and I saw no progress in favor of that decision. Hopefully we'll have a brighter future in this case. With that, I conclude my remarks, and thank you very much for your attention. Thank you. It is true. We have such association of exhibition organizers, and we discuss strategic issues with them. We discussed insurance issues with them, and there were two statements made by insurance companies. When museum people were asked what was the most frequent cases of incidents with objects when they are in transit or when they are in place? And the answer was that most of the incidents happen to those objects when the exhibits are in museums. The other point was that insurance people said that museums were the best clients for them because it's the only category of the people who can give up their values in favor of insurance premium. And that is really true, and because no premium can cover cultural value, cultural object of heritage. Since then, we have been trying to introduce the system of state guarantees because alone we are not capable of raising all the costs. In fact, the Minister of Finance took 2 sessions on that account. And the answer was that it's not beneficial for the ministry to save money for guarantees, but rather it's more beneficial for them to finance specific contracts, specific exhibitions. So I'm not a legal expert, but I'm a practitioner, and I saw a lot of system of insurance in Europe, and the best of them is in the United Kingdom, and they recognize everything, state guarantees and commercial guarantees. So they don't think that those guarantees impose quite a great burden on the state. And as a follow-up, I'm turning the floor to Anna Levzeneva, an expert from Alfa Strachovanie Insurance Company. And good afternoon, ladies and gentlemen. I represent Alfa Strachovanie Insurance Company, and as I was introduced, as my colleagues described my company,
Well, my company is one of the leading insurers of the Russian Federation, and I will be talking about the practice of insuring objects of art and culture as an integral part of cultural heritage. And I'll be talking about some key principles of my work. Now, a few words about the legal basis for our work and insurance. This is Federal Law number 54 about the museums of the Russian Federation, where the Ministry of Culture will have the authority to protect the objects of art and exhibits. And also another law, another provision which regulates the movement and the lending and borrowing of cultural objects. Well, you need to have a guarantee to receive a permission of the Ministry of Culture to export or to lend any objects of art. There's another provision which says that the insurance of the interests of residents of the Russian Federation must be done by a Russian insurance company only. That, which means that if a country would not issue, which receives the Russian art, would not issue guarantee, then there must be an insurance policy issued by a commercial insurance company and issued only by a Russian insurance company for that. In 2000, the Ministry of Culture, together with the leading insurance brokers and the experts of the domestic and international insurance markets, developed an insurance program for the objects of art and collections of the Russian Federation sent for temporary exhibitions. 2003, there was a letter from the Ministry of Culture which provided additional guidelines about this. And all the Russian insurance companies put their insurance programs for the works of art in line with the regulations of the Russian Federation. We see here the requirements for insurance as approved by the Ministry of Culture. I would not, of course, take your time to provide a detailed description of these requirements. I understand that many of you actually worked with such requirements and know about them. But I'd like to stress that the compliance of such rules with international standards made it possible to use very low premiums of only 0.1% of the collections value, but it is not enough to provide an insurance to make sure that such insurance will be paid out. The reliability of insurance would depend on reliable reinsurance, and hence we have some standards of reinsurance. The ministry instructed the insurance companies to provide optional reinsurance whose terms are identical or equivalent to the original insurance. The fact is that sometimes obligatory contracts of transportation or maritime or property insurance to cover also the works of art. And of course, such reinsurance in other areas is much less than the optional reinsurance for the works of art proper, but they are not adequate. Also, the insurers cannot keep on its balance sheet more than 10% of the risk, or more than 10 million rubles on their balance sheets, and some non-bona fide, non-diligent insurers do so, and reinsurance and protection should be provided by at least A- insurers according to the rating of the Standard & Poor's company, which guarantees the receipt that payment and insurance will be received even if the insurance payments are quite high. Well, when a policy is obtained by a commercial entity, there are no problems. But when we're talking about a government entity, such and insurance must be done in line with the federal law number 94 about state government procurement. And the most widespread practice is to organize a tender or an auction for such insurance services. And the only criteria for the winner is the minimum tender price, and that's why not only premium insurers were able to have access to such insurance services. But late last year, there were some amendments made to this law when close tenders can be held to attract insurance services, which makes it possible to invite only reliable insurers for the insurance of collections of art. Now, for the collections of art taken into the Russian Federation, the situation is that foreign museums insure their collections in foreign insurance companies. But if such powers are given to a Russian insurer and a Russian museum, then in each particular case, the foreign owners of the works of art require to have very strict rules applied from London for such insurance. But sometimes it is quite difficult to comply with such requirements. Well, Mr. Petrovsky asked Vladimir Putin for some facilitation, and there would be a mechanism of government guarantees developed for such deals. Government guarantees actually stimulate exhibitions and cultural exchanges, and we do hope that a government guarantee would be shortly available to Russian insurers in dealing with foreign museums. Insurance as a tool of preserving cultural heritage is also quite important. Insurers would provide protection and compensation for the damage, partial or full loss of a collection of art. And of course, when we're talking about total loss of a collection of art, we compensate in full, but then for partial compensations, we need to take into account the value of such works of art at the time of damage. The insurer actually introduces very high demands for the organizational and administrative and technical side of an exhibition. Insurers also have regular survey reviews, procuring such services from specialized survey companies. And there's monitoring and control of the whole preparation process for an exhibition. There's a detailed report with the deficiencies indicated and the requirements and demands for the correction. Such detailed preparation of an exhibition would minimize the risk of damaging the exhibited works of art. We may indeed conclude that the main mechanism of protecting museum exhibits and works of art would be the very strict control over the insurance products in line with international standards and the regulations of the Ministry of Culture. Second, the obtaining of solid and reliable reinsurance services. Third, preventive measures to minimize any possible damage. And fourth, using the services of reliable and authoritative insurance brokers and companies. We also need to improve the legislative basis which covers the insurance of the works of art. It is evident that only through concerted action and efforts of all the parties involved, that is, of the government, which provides for the favorable legal basis, of museum activities and exhibitions, of museums who display works of art, and insurers, of course, who understand the degree of their responsibility in protecting cultural heritage. Only through such measures would we be able to protect and preserve cultural heritage for future generations. Well, thank you. Indeed, we see it is pleasing to hear that insurers are in favor of government guarantees. But I have a question. We are joining WTO, and would there be any changes in terms of the insurance law? I mean, like countering protectionism, etc. I think that the law will have to be changed, and we are developing and moving forward, and some changes and amendments will have to be made, but we have to wait and see how it goes. Now I'll give the floor to Risa Tsugulova, who is the chief of the legal service of the Hermitage and a consumer of such insurance services. I would like to thank the organizers of this forum for inviting me here, and all of you who attend this section. It would be difficult to speak after my colleagues and my friends, my colleague from the insurance company really described a lot about this insurance business. But I'll be rather talking about something else. Well, I mean, I wouldn't be repeating anybody else, but on the other hand, there are some aspects that still remain untouched. We indeed are consumers of the insurance products, and the Hermitage has quite extensive positive experience in working with insurance companies, and it was often that through joint efforts we were able to overcome the deficiencies of the existing legislation. But still there are some challenges that we cannot overcome either at the level of our agreements with insurers and the reinsurance or with other companies that provide protection to our collections when exhibited abroad. Well, I understand that this is of applied nature, but for example, how do you determine the degree of damage to a work of art if we're talking about an insurance case? Because it is, again, this degree of damage that would define the amount of compensation that the museum would get. And of course, another important moment is the moment of insurance. An insurance company which has very low tariffs and high responsibility and liability limits would probably be attractive, but would they provide adequate protection? And for the museum, it is very important to assess realistically the degree of damage and agree on a certain share of such damage. But sometimes, as part of such agreement, we waste years on that. In 2009, we had a case in a French city of Aix-Marseille in a museum in the Jacques Delatour Museum, and one of our vases that were displayed there cracked, and for unknown reasons. Of course, there was an insurance value of the vase, and the experts from the Hermitage and the insurance company inspected the vase, and the Hermitage experts said that the damage is 50%. The insurance company claimed it was 25%. There was nothing wrong with the vase, but it was it cracked, but it was a Galle vase, and of course, if you look against the light, you would see that it is broken. And we have the best, I think, restoration experts in the Hermitage, and they did the restoration, but whatever effort you apply, still you would see a crack in the glass vase. And then the Hermitage agreed on the a damage level of 30%. The insurance company really wanted to pay only 25%. Like I said, this was an incident which happened in 2009. We repaired and restored the vase in 2010, but it is 2012 and we still didn't receive any compensation from the insurance company. And by the way, the insurance value of the vase was not that high. And claiming that whether this should be 25 or 30% is really not that's important, but I think that this is the general challenge of an insurance company. Like when you insure a car, an insurance company would always try and seek to reduce the value of a car, and you as the owner would try to increase it. But for museums, when you are talking about considerable damage to a work of art, or when you are talking about, say, a broken article from a pair of such articles, then the damage is very high. When the damage reaches like 60 or 70%, of course it depends on the liabilities and provisions of the insurance company, then you may claim total damage and loss of a work of art, and then the insurance company will have to pay the full amount of the insurance amount, 100%. But in this case, of course, the museum would cede this work of art to an insurance company. These are the rules. I mean, I don't know really how can you transfer an exhibit from a museum, which is put into the register of government property and public property, to a private company. According to the law of the Russian Federation on museums and museum activities, the only way you can really withdraw an item from a museum collection is through a particular decree or resolution of the Ministry of Culture, and it is not possible to do so in relation to a work of art which was damaged during an exhibition. Sometimes we had such cases. We had an insurance company which insured our collection in 2011, but through the fault of a designer who assembled the exhibit, and the designer actually dropped a glass bell on the stone floor, and of course we're talking about total damage. The insurance company in that case, as a result of the negotiations with the reinsurer, managed somehow, I don't know, to convince the Ministry of Culture that it is really not possible to provide this broken item to the reinsurer, but still get the payment, the compensation payment for that. But again, at the international level, we need to make some provisions and exceptions for the insured works of art and items of art which come from government museums, because they need to be treated in a special way. We are talking about public property, and nobody would ever be able to really give away government property to a private insurance company. So this is something to be probably worked on later. Another challenge that was mentioned, again, this is a nationwide challenge, and the challenge is related to the Federal Law number 94. Indeed, despite the requirements that were generated by the Ministry of Culture and published on the website of the Ministry of Culture, which protect the insured from non-diligent insurer, but still there's no special provision for the fine art markets. Indeed, we are talking about wall-to-wall rewriting of such norms, from other areas of insurance, and somehow such provisions are also transplanted and applied to fine art. Formally, of course, it would be in line and in compliance with the requirements of the Ministry of Culture. And then such a company which is not a trusted one may be involved in ensuring government collections. Thanks to the efforts of the Hermitage, and an amendment was made to the Federal Law number 94 about closed tender and bid for the insurance services for government museums, but only in relation to those exhibits which are lent by the museum. When we insure items that we receive, then this closed tender is not applicable anymore, and this tender can be open to any insurance company which is formally in compliance with requirements. But for example, if you're talking about a step-down auction, which means that the one who pays less is the winner.
From the standpoint of saving state money, probably it is reasonable, but it's not always the case. As I said earlier, the responsibilities and insurance rates are not correlated. So if insurance case takes place, then the insurance company finds itself in a very difficult situation. It won the tender for little money, but the responsibility is quite high. So from my perspective, I believe that the insurance of art is a kind of a positive image for an insurance company, because I don't think it's a profitable business for an insurance company. Because it is frequently the case that because of a single incident with a museum object, the insurance company may lose so much money that it may go broke. So, but it is really a positive image for an insurance company to have some contracts with the Hermitage, the Kremlin Museum, but for that end, they should treat it as things of image, and wouldn't engage us in protracted negotiations. And if some damage takes place, we would expect them to pay us the insurance premium quite quickly. And taking into account the fact that the insurance market is underdeveloped on either side, on this part of insurance company and on the part of museums, unfortunately we have very few experts on insurance in museums. And it's important to have such experts on this stuff in the museum, who could overcome the barriers in the insurance market. And for us it is important because sometimes reinsurers act not in good faith, and they produce such complex documents that even insurance experts cannot tell facultative from obligatory insurance. There is a very simple case. When after the earthquake and tsunami in Japan, 1 month later, the London market stopped insuring the earthquake risk because it, from probability, it turned into reality. So they stopped reinsuring that. And at that time, we had the insurance policy for the exhibition, which covered, among other risks, the risk of earthquake. It means that the insurance company was not sure what it was producing. And if something had happened in Japan, like in Japan, the company would have borne all the responsibility. insurance value of any collection of the Hermitage is very much in excess of $10 million, despite low insurance rates. So I think that the museum that is really responsible for their collections, who realize that they have all responsibility for keeping the historical heritage, should not be afraid of being accused of not being loyal, and would have to ask all the documents from the insurance company. And it's a reinsurance slip and endorsement. All documents are to be made to be available, as well as the covenant. So I think if those documents are produced, and if it is part of a statement of work and contracts, it would offer some protection. And what is most important, as I pointed earlier, we need to have some experts on our staff who would really read those documents. So speaking of those problems, the problems which may look not significant from the first glance, but for us they are really important. Good faith of an insurer is really very important, and when each party informs the other all the details of the execution of the contract. And on the other hand, the museum should not be afraid of overseeing the insurance company and take some measures and actions despite the agreement concluded. I think that concludes my remarks, because my colleagues already made their points about the state guarantees. And President Putin spoke recently about the same things at the meeting in Saratov. But once again, according to the Prime Agency, insurers are quite skeptical. So they are quite skeptical about the possibility to reinsure cultural values by non-core organizations. I'm not certain what the outcome will be, but I would like to see the joint effort in this area, enabling us to really have good results. Okay, thank you very much. We have completed our first round of presentations. We have a lot of food of discussions. Probably we'll start with questions to presenters. But before that, I would like to touch upon one more thing. We expected Mr. Stefanelli to come then to attend here from the Hansen Lutheran Parks, but unfortunately he fell sick and couldn't come. But in his talking points, I think one can find three important things. And he starts with an excellent ruling by Judge Crook of 1814, who ruled on a petition on behalf of the Philadelphia Academy of Arts that asked for the return of paintings and prints taken by the British from an American vessel during the War of 1812. And what is important about that ruling is that the same law of nations which prescribes that all property belonging to the enemy shall be liable to confiscation has likewise its modifications and relaxations of that rule. So the arts and the sciences are admitted amongst all civilized nations as forming an exception to the severe rights of warfare. And we know about its follow-up. It's the Hague law and other things that you cannot seize and not confiscate objects of art. And Neely further explains that this principle is even deeper, and he claims that some other principles are to be developed for the objects of arts, and I think it equally applies to the immunity from seizure, because it's really a counter to the customary international laws and human rights. He further speaks about some historical facts, and he says that mostly Russia contributed to the development of that institution of protection, and the famous U.S. law that does protect well from seizures in case of a non-commercial case. Was drafted because of the first Soviet exhibitions exhibiting the ancient Kiev, golden objects and other things. In many countries, some acts were adopted, but mostly they relate to the Russian or Soviet exhibitions. Although we can recall some cases of the Soviet exhibition that was removed from Paris very quickly because of some claim, but it was also the case with the United States with the El Greco painting that was displayed in Spain and that was evacuated from Spain by plane. But those were the extreme measures taken by the great superpowers, and some juridical measures were introduced later on, particularly in France, following the Matisse process. In Germany, the museum organizers 1 year later adopted various statutes in various lands with similar rules, and after that probably we can hear about the Dutch experience. I think the Dutch government can also take such decisions, failing to observe certain rules. The last case was in the UK, and again Russian exposition was involved. So I think it's a very important experience for us. And in Russia we have a habit saying that we are always lagging behind, we have to keep up with the best countries, best experience. But sometimes Russia contributes to some novelties. And I think it's the first time when the International Legal Forum is organized by both the Minister of Justice and a major museum, and everybody enjoys that. So in his talking points, he speaks of various claims, and he says that the governing law in the United States guarantees that cultural loans are not in danger because they cannot be seized if the objects are brought for non-commercial purposes. I wish Mr. Nally is here, were here, but if so, I would tell him about the Chilean case, and I understand that the law of the state of New York didn't protect those art objects from seizure. So situations are different, but today we mostly hear some optimistic views that both statutes and law practices give us all the opportunities to protect, to ensure protection of cultural values on loan. And that's the good thing of the cultural values, that they can be given on loan. So, dear colleagues, I wonder if you have any questions on those things that we have discussed. And then probably we will have some discussion because I suspect views can be different. So questions first. Очень хорошо. I'm Maria Alexandrovna. I'm the Civil Law Department representative. I would like to ask Anna Dost. It was really interesting. So Ms. Dost was telling about law of 1984 or 98 of the Constitutional Court ruling, which interpreted, and she interpreted quite efficiently some of the provisions of the, and if I'm not mistaken, it was the case of Martin Nirenberg. Am I wrong? We had an experience with a claim of a foreign citizen to the General Jurisdiction Court, but it failed. But it seems to me it doesn't prove that the legislation is totally inefficient. And we cannot say that at the governmental level, and here we can confirm that Russia is taking an effort to fulfill all the commitments ensuing from a 1998 law. So I wonder if in Germany those efforts are visible, if you really see those efforts, or you are still so pessimistic about your assessment of 1998 law.
First of all, shall I respond directly, or do you want to collect questions to all first and then just collect the questions and have then the answers?
I don't think there will be too many questions.
Okay. So I just...
Готов написать письменно, то давайте.
If you are prepared to submit questions in writing, you can go ahead with that.
I'm not sure whether I got your question correctly. As you are more pessimistic to the effectiveness of this German law, or vis-à-vis Russian cultural assets?
I'm sorry, maybe I was speaking too fast. About how you consider Russian legislation on this Transnistria cultural treasures. Do you look pessimistic on this subject or not?
You mean
what was your position, please?
Like the position in general from my law firm? Okay, we are mainly representing Jewish heirs claiming art, like lost Nazi-looted art, which means art confiscated by the Nazis in the 1930s in Germany, as well as in France or the Netherlands, then mainly via this infamous Einsatzstab Reichsleiter Rosenberg. And of course, some of these art objects they were sent to Germany, and then the Soviet troops in the eastern part of Germany, Berlin, of course, took them with them back to the Soviet Union. And comparatively to the laws enacted by France, the Netherlands, of Germany, of course, due to their historic guilt, and adopting these Russian principles, which were after the adoption of the Russian law, of course we are pessimistic because vis-à-vis in the other countries, Jewish heirs or people not actually have to be Jewish, but also might be anti-fascist, but normally they don't have lost so much cultural assets, but it's also possible that they are non-Jewish, of course. They could just turn to the museum who holds these cultural valuables, paintings, whatever, and seek together a just and fair solution, which doesn't always mean that they want to have the painting or the cultural asset back, but also that it can remain in the museum, as was mentioned also by Mr. That they can find a solution where the painting or the cultural asset remains in the museum, that maybe it's negotiated on a sum which is or sometimes there might be a very, very different solution, but that you can really negotiate directly with the museum or the cultural institution holding the painting. And the Russian version of having to claim it through both the foreign ministries and then through the Ministry of Culture of the Russian Federation is, of course, I mean, it takes years, of course, because there are so many intermediaries involved, and it's always really easier if, like, both parties come and sit on the table directly. So, yeah, of course, as a legal representative, we see it in a pessimistic way. If this was your question.
Thank you.
Спасибо. Если позволите, я тоже чуть-чуть.
Okay, so if I may, I'll give you another comment and say that you cannot speak of direct negotiations because everything that is kept in museum is part of the foundation, museum foundation of the Russian Federation. So you have to approach the Russian Federation government. As for the talks or negotiations, there is no problem with that. And as was pointed out, the law was amended. And based on that, the Hermitage passed. And actually, it initiated the passage to the hegemony of some churches' objects, and not religious objects belong to the church, but still. And sometimes we see a lot of anti-Nazi victims who, if checked, they are not victims of Nazis, but they collaborated with Nazis themselves, and it also sometimes happens. We negotiated on the Baldwin collection from the Bremen Museum, and we decided and we negotiated some things that can be done in order to find a good solution. But the moment the German media learned about that, there was so much outcry that it was too late, and actually the opportunity for the deal was killed by that outcry of the media and negative reaction to that. The German courts, they take some sober approaches, and we know cases about Rubens' painting taken by a Russian officer, sold, resold many times, and bought by a Russian collectioner and was seized. And then the German court made a ruling that in this case it is collectioner in good faith, and you cannot seize the painting from him. So I have a feeling that all laws can be benefited from if.
Any other questions, please? My name is Dmitry Maziev. I'm from the Art Supervision Interest Group, and I have a question to the insurance companies. To insure an object of art, you need also to provide a value of such an object of art. But any standard approaches to establishing the value of a work of art are not proper. So which methods do you use in determining the value of a work of art or an object of culture? Thank you for the question. Indeed, this is a question not really to the insurance companies, but to the museum, because it's the museums that have a certain procedure for establishing the value of a work of art, the so-called procurement commission of a museum, which determine the value of this or that work of art. And insurance companies, actually, it is put into our contracts that we assume the value assigned by the procurement commissions of museums. So again, it is the museums that determine the value, and this value is then reflected in the contracts, in the insurance contracts. Well, we are insurers. We are not experts in museum values and values of the works of art. Any more questions? Yes, please. Also, a question to the insurance company, Natalia Kristianinova, legal counselor for the Hermitage Museum. You mentioned that you trust the museums in determining the value of works of art, and you trust our assessments, but then why do we have all those differences in determining the damage caused to a work of art? And then you later claim that you don't trust this evaluation or valuation of a work of art in an insurance case. Thank you for the question. As far as I understand, this is a question which was inspired by the story provided by Marina. We many times claimed that an insurance company issuing its insurance policies at the request of the Ministry of Culture need to provide reinsurance, and reinsurance is an optional proportional insurance of 10% of the insurance company, or no more than 10 million rubles, and then the 90% of the rest falls on an insurance syndicate established by Lloyd. We actually ask the London market and the British insurance companies whether they can support us in an exhibition project. And since in such transactions, pardon my rough language, you also have many parties involved, then there might be differences in approaches. I'm fully aware of the insurance case with the Galevas that was cracked, but I hope that it would be an exception which would be considered as such. In a normal insurance practices, if there's no agreement between the insurance company and the museum, you would call in an arbiter, a mediator who would really help the museum and the insurance company to reach an agreement on the valuation of a work of art. Indeed, based on the reinsurance terms, there are some standard procedures for mediation, and the fact is that by agreement between the parties, you choose a mediator, an expert who would finally provide a valuation of a work of art. But here, the key word is by agreement between the parties. Referring to this Galevas case, we never were proposed an expert who would be involved in this process as a mediator. Now, if we follow strictly the rules of reinsurance, we need to be universal in our approaches. If we have some time established for the involvement of a mediator, we need to be in compliance with such time and terms. And this is essential both for the insurance company and the museum. And of course, I understand that this story is not over when we're talking about the relations of the Russian insurance company and the museum. There is also the London market, and there are traditions that have been established for centuries. And these are set rules. And if we follow the rules and the procedures, it would be important for the relations between the insurance community and the museum community in Russia. Sergei Grishin, director of the Yamalo-Nenets Museum. In your presentation, Mr. Winterberg was so convincing in saying that based on the international law, the cultural objects actually assume some immunity, which is not debatable, but Mr. Barbato, when talking about the circulation or movement of the works of art, compared this to the free movement of goods. That leaves the actually the whole story open for any arbitrary interpretation. What do you think about this? This is not my position, I should say. This is not my subjective opinion. This is the opinion of the European courts. There are courts, and the question was put in the following way. Back in time, Italy introduced a tax, an export tax, a tax on the exports of cultural values. The common market of Europe applies a zero tariff for imports and exports of the works of art, and the Italian court did not want to violate anything, but the idea was not about goods, but about cultural values. So there was an autonomous interpretation of what cultural values are. And if each particular country would follow the suit, then the whole situation would be very much confused. And the European Union then claimed that we need to distinguish between tradable goods, something for trade, and between non-tradable goods. There were also copyright issues. Goods are goods, and cultural values are cultural values, something very much different. And it was important to provide for the free movement of such items of art across the borders. And then the government really wanted to introduce a cultural dimension to the valuation of the works of art to provide for the freedom of movement of such items without any restrictions. Transfers, movement, etc. When I mentioned the legislation of the European Union, I actually focused on the legal aspect of the whole situation. But paradoxically, there is also an ethical aspect, and it seems that cultural values and the works of art are still viewed as goods, and this is the most efficient law, with an exception which provides this exception for museum of items, and in this way we can say that there's no harmonized approach at the level of the European Union towards this. This was just a way out of this situation. We just wanted to make sure that national legislation would not really block or stop the exchange of cultural values. We just wanted to push the process forward to be efficient in the common market. We need to make some exceptions. This just happened during the time when the European Union was established. Again, to define a cultural item as goods with an exception was easier to be done than having a separate piece of law for cultural values. And the law of the European Union, of course, recognizes the special nature of such works of art. I should also mention that the European Commission was very active in preparing the UNESCO 2005 Convention on Cultural Diversity. And I should also mention that the EU law has an adherence to such cultural diversity. Article 167, paragraph 4 of the European Union Treaty says that when there are certain actions with consequences for culture, the European Union would take this into account, something that might impede on the cultural heritage. Coming back to your questions, again, it seems that we had to mention goods, so go through trade with an exception for the museums to operate and interact freely.
Thank you. To give an addition to that, basically, mobility of collections has been one of the key issues within the European Union since the beginning of this millennium. It has been set on the agenda, for instance, in 2004 when the Netherlands was the EU presidency. And also based on the work plan of action of the European Union, a working group on mobility of collections has been set up. One of those subgroups was an immunity from seizure subgroup, which came with its report in June 2010. And based also on the inquiries which had been sent out to all of those 27 EU member states, the subgroup immunity from seizure came to the conclusion that the idea that cultural objects were immune from seizure under customary international law was widely supported within the member states of the European Union. And that is one of the key recommendations also of the working group on immunity from seizure. Also that each state has its own approach. Each state is very keen on protecting cultural objects while on loan. And the majority of the member states already follow this approach through the rules of customary international law. Some states have its own legislation, like for instance Germany. Germany has very appropriate legislation in regard to immunity from seizure for cultural objects on loan, like has some other states like France, and the Netherlands has legislation as well, but not specifically related to cultural objects, but related to state property. And also, so there are different ways which may lead to Rome, but on the whole, basically, the immunity from seizure approach on the basis of customary international law, that is an approach which is merely followed by the member states of the European Union, as also expressed in this report of June 2010, which can be found on actually the website called landingforeurope.eu. Thank you.
Si je puis me permettre, je voudrais également rajouter quelque chose à votre intervention.
If I may say a few additional words to this, what I tried to explain was that we did not really develop any regulations or rules, but rather prepared some recommendations, but jointly, and we realized that we have to push forward. The situation is far from being ideal, but we had to do something, so we had to have an expert evaluation. We had to spend time on research, but in the meantime, we had to act, and just relying on goodwill is not enough. We are now looking into the possibility of developing some regulations and rules, using such national legislation which has some positive aspect to them, to provide for the mobility of collections. This was a practical approach, and recommendations and expert opinions are being studied now. We would probably, hopefully, reach a result that would be suitable for all. We are all together, and this is the essence of the European Union.
As you proposed for the American legislation that you alluded to in your presentation, can you just explain it or elaborate a bit more on it, like on the prospects of this legislation in the US pending in the Senate, and what you expect from it, also for a Russian perspective? Mr. Waterholt?
I know only a little bit about this possible legislation in the Congress of the United States, and maybe we can hear from you some more.
Thank you. Well, first of all, one of the problems which are now pending in the United States has not so much to do with immunity from seizure, but more with immunity from jurisdiction. I mean, we are here International Legal Forum, so I assume that the difference is clear, but still, And you referred to the Martha Nierenberg case, for instance, which is also actually basically known as the Herzog case, where basically the Hungarian Republic as well as different Hungarian museums are the defendants. There again we are talking immunity from jurisdiction, not immunity from seizure, because plaintiffs want to get cultural property, which has never been so far in the United States. So they did not try to seize property in the United States. The same goes for the Shearson case or the Shabbat case, where the Russian Federation was the defendant. There again, we are talking cultural property, which has not been exhibited in the United States. There we are talking about the Foreign Sovereign Immunity Act, which basically provides immunity for states, but has certain exceptions. And one of the exceptions, for instance, is the so-called commercial exception. And the plaintiffs are making some constructions in that the Russian Federation or the Hungarian Republic or an agency or instrumentality of the state is having some commercial action in the United States, and on the basis of that, those states or instrumentalities are sued in the United States. So that's immunity from jurisdiction, not so much immunity from seizure. What we have in the United States is an immunity from seizure legislation, the Immunity from Seizure Act. That basically says that cultural objects on loan can get some kind of public notice from the US State Department, and on the basis of that public notice, the objects are immune from seizure while in the United States. As a matter of fact, the background of that notice, and that is not so much to protect the cultural objects, but it's merely to protect the American borrowing museum, so that the American museum would not get rid of the cultural objects which are temporary within their walls. Well, actually, so then you have an Immunity from Seizure Act, which provides immunity, and you may have the Foreign Sovereign Immunity Act, which has an exception to the immunity, so which says you do not have immunity. So that can clash. So now there is this law, this draft law in the United States, which then says what law does prevail? Does the Immunity from Seizure Act prevail, or does the Foreign Sovereign Immunity Act prevail? And the gist of that law is that immunity from seizure prevails, with one very important exception, and that regards Holocaust confiscated art. There you have when it turns to be Holocaust confiscated art, then the Foreign Sovereign Immunity Act, which has its exceptions, prevails so that there is no immunity. Of course, you can have questions like, when do we speak about Holocaust confiscated art? When is there plunder? Where lies the burden of proof? And all that kind of stuff. And I have to say that probably this has not been well established yet, but basically that is now the current state of affairs. It's now in front of the Senate, and it's expected that it will be adopted and that it will be signed by the President somewhere after the summer. And what happened with Portrait of Wally, which is here on the front of my book, the Portrait of Wally did not, the Museum of Modern Art in New York did not apply for immunity under the federal system. It only applied for immunity under the state system. So two things happened. First of all, it had immunity under a state law, but then it had been confiscated on the basis of a federal law, so that was a higher law. And then also, although the court case specifically focused on what happened in Austria in the 1950s, it is still regarded Holocaust confiscated art, because originally it had been sold by a private individual under duress in 1938. So that is another reason why it would not fall under the immunity regulation in the United States, as it's considered to be Holocaust confiscated art. So that's basically now the current state of affairs in regard of this legislation in the United States. And it's hoped for by the legislators that it will give more clarity, and that it also will take away fear from foreign lenders that their objects will not receive immunity, so that it's clear, so that if it's Holocaust confiscated art, whatever it may be, it will not receive immunity. In all other situations, it will receive immunity.
Dear colleagues, any other comments, remarks, questions?
I'm Wojciech Kowalski. I'm from Poland, from the University of Silesia. Just short question. How would you comment the non-commercial clause in the context of blockbusters, so-called blockbusters exhibitions that are sometimes understood as more or less commercial events, although if organized by museums, the commercial means to raise more funds for the museum, so for the not commercial papers at the end. So if it makes it more problematic or not at all. And if I may, I would like to ask also a question to insurers community. Would you insure the work of art to be loaned against the risk of the total loss of this work of art in result of the successful claim of the dispossessed owner? Dispossessed, for example, Holocaust, doesn't matter, loot, war loot. Or this is more complicated, so don't put it to the one basket. Thank you.
Thank you. In regard to your first question, that's a very interesting question, also because what's commercial or not is sometimes approached differently. For instance, when you take the UN Convention, that goes from the perspective that because cultural objects on loan, owned or possessed or controlled by states, are being used as some kind of, what I called it already, goodwill ambassadors, and because it helps the mutual understanding and mutual bilateral ties between states, by definition, it cannot be considered as commercial, although, I mean, a lot of money can go around with it. Also, this non-commercial prescription in this public notice, as such, also goes from that same point of departure. But what you saw, for instance, in the Malevich case in the United States, where the Stedelijk Museum Amsterdam gave 14 artworks of Malevich on loan to two cultural institutions in the United States, after those objects had been returned to Amsterdam, a suit was filed by a group of 32 heirs of Malevich. There, the US District Court and also the Court of Appeals stated that here we are dealing with a commercial activity and because of the fact that the Stedelijk Museum Amsterdam asked for a loan fee. The executive for the executive branch in the United States, the State Department, filed several statements of interest stating that this should not be considered as a commercial activity, but based on the trias politica, where we have the distinction between the legislative, the executive, and the judicial branch, the judicial branch did not agree with the executive branch and said that because of the fact that a loan fee was involved, that was the reason that the judicial branch considered is. So basically what I want to say with this is that the question may be answered differently, probably regardless of whether the answer is being given by the executive branch or by the legal branch. And there sometimes it also depends basically on the legal branch, on how much value they put on the statements of interest by the US Department of State. Because what I have seen in the jurisdiction is that some district courts put very heavy weight on the statements of interest of the US Department of State and actually do not want to depart from that, whereas there are other district courts which are a little bit more willing to put those statements of interest aside.
Responding to that question, I would say that insurance means that the insurance case occurs or not. And if there is the probability of insurance case is 100%, personally, I wouldn't assume such a risk, despite the fact that there are legal grounds to be reimbursed for that. So I wouldn't stay short of being engaged in all those deliberations.
Пожалуйста, кто еще хотел бы сказать, высказаться? Пожалуйста.
Any other comments? From the standpoint of the civil law and the insurance contract, and understanding the risks as a necessary element of insurance relations, you believe that such kind of risk cannot be insured because of the civil legislation. According to the legislation, if we believe that the probability of such an event is very high, we do not have a right to insure that. We otherwise provoke the insurer to create some actions that run counter to insurance policy. But it's not always that we know that there is such a threat, and if we understand that there is a threat, we do not do anything on loan. You know, at some point we discussed that issue with reinsurers, but the coverage was so high. And it was unreasonably high, so the progress was not made. More questions, please. I would like to ask Mr. Nout van Banderbank, and we are very impatient or indifferent to the situation when we stopped our exhibition activities with the United States, and one of the reasons for that is the necessity to improve U.S. law, and the Russian side insists on that. We were debating those things with the U.S. counterparts. We sent requests to the Metropolitan Museum and to the National Gallery, and they responded by saying that some steps for improvement are being made, but it doesn't mean that some notions will be more transparent. But at the same time, they say that the federal law in effect of 1965 of judicial immunities protects cultural objects quite efficiently and effectively. So our U.S. counterparts cannot see any legal barriers so that Russian objects of culture travel to the United States. So my question goes to you as a professional. Could you share with us your opinion if it is really necessary to change, to amend something in the current U.S. legislation, and if there is any threat to the cultural objects on loan in light of the Schneerson Library case? Thank you.
Thank you. Oops. Well, indeed, I do think that the 1965 federal legislation is an appropriate legislation. However, what we are facing here is that it's a federal law, so basically it's a national law, and that the Foreign Sovereign Immunity Act is a national law as well, a federal law as well, so they are on equal level. So it may very well be, and I agree with the US executive branch, that the law of 65 is a proper piece of legislation, but you do not know, and that is basically what I said as well, how the US courts are reacting on that and what the US courts are doing when they have, on the one hand, this Federal Sovereign Immunity Act from 1965, and on the other hand, the Foreign Sovereign the Immunity from Seizure Act from 1965, and the Foreign Sovereign Immunity Act from 1976. So, because that are on equal standards, and one says you have immunity, and the other says, well, you have immunity unless there is expropriation, commercial activity, etc. And for that reason, this new legislation will give the balance and will say what kind of law prevails. So that's a good step. I already said that on the basis of customary international law, those state objects would already be immune. And also that is something which is merely supported by the US government as well. The problem is basically that US courts have to apply rules of international law. And what you merely see is, and that's a general tendency, what I see in US courts, is that US courts are first and foremost looking at its own legislation, either on state level or on the federal level, and not all courts, especially on the field of the districts court, and I really do say that in my personal capacity, have that overview of international law. So that means, and that you see that in all different kinds of countries as well, that it's when it comes to court that you have to wait and see whether indeed rules of customary international law are applied by a local court. Basically, we saw the same last year in Vienna. There we had the seizure of 3 cultural objects owned by the State Republic. They came from the National Gallery in Prague and the Moravian Gallery in Brno. There, on the request of a company called Diagumen, these 3 objects were being seized because this company said that the Czech Republic owned there so many $1 million, euros, crowns, whatever. And the lower court seized indeed, or gave indeed permission to seize the objects. Then there came an intervention, a mutual intervention, a common intervention by the Austrian and Czech authorities, saying that on the basis of customary international law, it would not even be possible to seize the objects, because these are state-owned objects with a non-commercial public purpose. And then the higher court in Austria said, indeed, on the basis of customary international law, these objects are immune from seizure, so the seizure had to be lifted. What I'm saying to that in the end, it all ends well and the objects went back to the Czech Republic, but a lot of harm already had been done because the lower court did not take into account the appropriate rules of international law. And that can happen in any country, of course. So that's always a risk. So yes, I agree that the 1965 law is a good one. I agree there is a rule of customary international law, but in the end, the court, the judicial branch, always has the last say, and you don't know for sure whether the judicial branch has the same kind of approach.
Пожалуйста, есть ли еще желающие задать вопрос?
Any more questions, remarks, comments? My question will be very short. I'm Professor Daryanska from the law school. You know, Mr. Darand, I liked your point that cultural objects, cultural values are subject to special regulation. I fully support this idea, but I wonder if the Ministry of Culture shares the same view, or it's going to be our own personal idea. Actually, the head of the legal department of the Ministry of Culture sits next to you. Probably we'll hear from him. Dr. Good afternoon, dear colleagues. In the country, there is a set of legislation aimed at the protection of cultural objects. So we're talking about the law on moving mobile objects. It's law 73, and other laws that apply to the historical objects and heritage. So we actually set up the regulatory base that regulate the circulation of the cultural objects given their specific status. That's my answer. May I follow up? I would never agree with that statement, and I cannot agree with that, because given the situation with exhibition activities and all other poor cases, and our treatment of cultural objects would be quite different if we had adequate protection. In fact, it's not in place. Starting from our initial idea, what terminology are we using? Because some people say objects of cultures, others prefer to say cultural values. What do you mean by cultural values? In which law there is a definition of cultural values? And we keep on using those terms, although we are fully aware of the fact that the international conventions use cultural property. And property is something else. And the property is substance in Russian. And you claim that things are fine in our case. It's not.
I think much needs to be changed, not only in Russia, but also internationally. I think that UNESCO is doing a lot, but I think that we're talking about some scattered efforts, but we don't find any international comprehensive regulation or convention about museum activities. So I think that we need to protect cultural property in peacetime as well. In wartime, there is a protection mechanism, a convention and protocols, etc. But what about peacetime? Why would we always face questions about nationalization, confiscation, property rights on cultural property, etc.? Indeed, it is because all countries behave themselves the way they want. Now, I would think that if we would implement your proposals, we would probably be ahead of all. Well, I won't take much of your time, but I'll just say that the notion of cultural values, as you claim, it is not available in the Russian law legislation, but it is available in the law on Russian museums, in the framework law on culture of 1992, etc., etc. And now, as far as terminology is concerned, I should say that we do have all the required notions and definitions, but we also have challenges. But this is not about the regulatory framework or lacking laws on the protection of cultural values, but it is about enforcement and application of law. We are talking about legal nihilism, about a negative attitude to legal norms, the unwillingness to comply with the law, and some professional communities establish their own rules and regulations which are not compliant with the overall legal legislation and rules.
As a matter of fact, when I remind the 2005 Noga case, where in Switzerland in November 2005, different cultural objects coming from the Russian Federation had been seized for a short period of time. There it was the Russian Federation, together with the Swiss government, who was very vocal in stating that also on the basis of customary international law, basically the same situation as happened last year with Austria and the Czech Republic, that on the basis of customary international law, these objects are immune from seizure. And last year, when I was in Moscow for my book, I had an extensive talk with the legal advisors of the Ministerstvo иностранных дел in Moscow, where again it has been confirmed that it's the official position of the Russian authorities that on the basis of customary international law, these objects are immune from seizure. That leaves aside that you still have Article 30 of the Russian law on the temporary export and import for cultural objects, which gives a listing of documents which should be given by the borrowing country to the lending country, and immunity from seizure is one of those documents. But that basically also leaves, that leaves aside the fact that in the International Legal Forum, the Russian authorities are very vocal in saying that because all the property of the State Hermitage Museum and of the Kremlin Museum and all the other valuable museums should be considered as I already called it, goodwill ambassadors, that for that reason, and that's exactly why also the Russian Federation supported the Article 21, you saw it on my PowerPoint presentation, of the 2004 UN Convention, which says that cultural objects on loan belonging to foreign states is one of those 5 categories of state property which cannot be seized because by definition it should be considered as having a non-commercial sovereign public annotation. And basically, that's so I would say that indeed there is this general approach, and the fact that some states have its own legislation should not be seen as a contradiction to that fact, but could also very much seen as a confirmation to that fact, a confirmation of the fact that legally speaking, those objects ought to be immune from seizure. Thank you.
Если можно, у меня,
Well, first of all, I would like to thank all participants in this roundtable discussion, but I have some comments. I think that you, acting as one of the moderators of a legal forum, could be praised not only from the legal community, but probably you can be blamed also for the legal community lagging behind our ideas. Indeed, we don't have any strong legislation in Russia which would cover the lending of the works of art abroad, but we do have very active programs of sending our art abroad. Perhaps there needs to be some covering or some narrowing of this gap. Now, there was an issue about the claims of the insurance companies, but I don't think that there are many such disputes with the insurance companies. We ask them to insure some works of art, and they agree in most cases with such assessments. So we probably forgot to mention another player in this field. I'm talking about the one who is paying. We are insuring and we are paying, but sometimes it is not, and there are some particular issues that might cause a concern that the terms and regulations used in each particular case could be different. But when people don't agree with the expert valuations, then it's a point for discussion, and I would like to make a rapprochement here, indeed, between the practices in the Russian Federation and what is being done in the European Union. We actually add another element that cultural objects are goods. Well, we, I think, also consider cultural objects as goods because we sign customs declarations every day, and that cultural objects are treated as goods or commodities. And I think that this is nothing unusual. On a practical scale, this procedure is already being used in Russia as well. And I think that we also need to follow the practice of the European Union. I listened to the discussions about various working groups, but I think that the working group on the mobility of collections really has to make an arrangement with the subgroup on the immunities. In continuation of our discussion between Ludmila and Kirill, and also thinking about what Dmitry just mentioned, here I fully support Ludmila in that we really don't have any clear definition of cultural objects or cultural property or cultural values. Indeed, we heard about several laws, but one of the laws actually refers to another law about the exports and imports of the so-called cultural values. But there is no definition in that law. And in particular, this is a hindrance on our exhibition efforts. The State Hermitage has tried repeatedly in the last few years, but we are successful now. There is already an order of the Federal Customs Service on that particular issue. And the issue is that since all our cultural property or values commodities, and since some of the items of art contain precious metals, they need to be inspected by the so-called commodities customs stations, and there they actually inspect other precious metals or oil or other exports, and those stations are abroad. And now, if the frame of a painting contains some gold, you have to deliver this painting to a customs station outside the city in a bad environment for the painting, in the presence of various lube oils, etc., etc. And this is, of course, not acceptable. But the problem is that there is no distinction between cultural property, cultural values, and other commodities. There is no definition at all, and it is easier to call it just commodities. We have fought for it for many years, and we asked to make an exception for the works of art which contain precious metals and exclude such items from the list of items that need to be inspected by the commodities and excise customs stations. I should say that, or maybe ask of the Ministry of Culture representatives, and we've been talking about legal nihilism, but there is also a definition contained in some pieces of legislation, and lawyers really cannot understand the wording of such a definition, cannot be sure what it is, but even more so, we have bits and pieces of legislation. We don't have we have such norms in the administrative code, in the civil code, in the criminal code, and in the law on cultural values, and different terms and wording is used there. But claiming that modern legislation about cultural property is adequate to modern reality is not possible, since we still have a guideline dated 1985 about the storage of cultural values, and this guidelines are still in force. Again, we need to put our legislation in step in sync with modern realities. Thank you. Again, to continue this discussion, I am a student of Lyudmila Nikiforova. My name is Janat. I come from the Republic of Kazakhstan, from the legislature of Kazakhstan. A few comments about lawmaking. It is obvious that when we discuss the theme of our section, we are talking about lack of coordination between the Ministry of Culture, Ministry of Justice, and the Ministry of Foreign Affairs. I think that the leading agency here should be the Ministry of Culture. And perhaps after such broad discussions and the challenges and issues that we discuss here, we perhaps need to be more proactive. And this concerns not only the Ministry of Culture of Russia, but these issues are topical for the Republic of Kazakhstan as well. By the way, when we are talking about relations between Kazakhstan and Russia, I should say that most of the issues were resolved about the retribution of the works of art to Kazakhstan. For example, the works of Shulikhan Abukhanov and Alikhan Batuhanov to Kazakhstan from Russia, where those works were held, and I think that the Ministry of Culture really need to establish some working groups and work on a legal act on to be adopted by the Ministry of Justice and to legally formalize any exhibition and museum activities, and also coordinate its efforts with the Foreign Affairs Ministry, and this would probably be a good solution. And we, of course, need not forget enforcement mechanisms. Yes, was mentioned by the representative of the Ministry of Culture. But so what I wanted to say is that it is not only about lawmaking or law enforcement. It is also about the efforts of the appropriate agencies of culture, museums, and other interested parties. And as Ludmila mentioned, then we would be ahead of all in such endeavors. Well, again, the question probably was addressed to me. What I wanted to say, really, is that there is a code of legislation pertaining to culture of 1992. There is a definition of cultural values. There is a full description of both material and non-material objects of culture. And Ludmila and others mentioned that indeed we're talking about quite scattered definitions in various laws, but those definitions are used for the purpose of those laws. And indeed, the 1992 law contains quite a few norms which are not applicable today or are not in use today, because about 2/3 of such norms are no longer valid. But we cannot claim that those norms are not used at all. They are used by a courts, for example, in trying to find compensation for damages through unsanctioned use of objects of culture. There's also a law on museums, and this regulates the activities of museums in this country, provides a definition of the museums, and also provides for the principles of the operations. And there is also a mention of, or definition of, the cultural values, but with a reference to another piece of law on the exportation and importation of works of art. Why? Because there you have a more developed procedure for the exportation and importation of material cultural objects. And the definition you can find there, and the definition is based on the conventions ratified by the Russian Federation. I can agree with you that indeed we have some discrepancies in terminology between the criminal legislation and the civil law. If we're talking about cultural items in civil law, but then in criminal law we have other definitions, but this pertain to the crimes of not returning such cultural objects or items of art back to the territory of Russia, etc. Yes, indeed, there is no uniform terminology used, but I can tell you that the Ministry of Culture currently has a working group which is working on harmonizing legislation and actually streamlining the legislation on the protection of archaeological sites, which is a serious problem because we know about all those abuses committed by the diggers who use metal detectors to try to dig out something of value for them, and they destroy in the process many of the archaeological sites. Now, through this, we would want to provide one single uniform terminology and perhaps use the notion of cultural values that would also refer back to the exportation and importation law, which provides actually a detailed list of what is considered to be cultural values. And perhaps also a new definition can be put in line with the international conventions ratified by the Russian Federation. Now, regarding some cooperation between the Foreign Ministry and the Ministry of Culture that you mentioned. I can say that as far as my job is concerned, the job of the Ministry of Culture and its legal department and other core departments and our cooperation with the Foreign Ministry, I can only highly praise such interaction and cooperation. We do have very good cooperation, but this is my point of view from the Ministry of Culture. We don't see here any representative from the Foreign Ministry, so we don't know their position. But I should say that our cooperation is very comfortable.
Thank you very much. I think we're coming to the close. I would like to ask the presenters if you still have any ideas to share. One more comment. I'm a lawyer from the Mariinsky Theater. I would like to add that the circulation of cultural values, it involves not only exhibition activities. Sometimes we are faced with totally unusual cases, and unexpected legal problems arise, both domestically and outside the country, specifically when our society became open. Well, I would like to thank all my colleagues who identified all the details. I'd like to thank Mikhail Borisovich Beatrovsky, who raised the topic of the cultural value of circulation at the forum. I think it's for the first time when I hear such a serious discussion of cultural value circulation, both domestically and internationally. And otherwise it's kind of exotic, both the domestic conferences and international. Just to give you a simple example and to underline the multifacetedness of that problem, quite recently we had we were on traveling in Germany, and works of Richard Strauss were not protected in the territory of the Soviet of Russia because it was not a Russian author. And the rights of Richard Strauss are protected in the territory of the Russian Federation, and we export notes that the Mariinsky Theater, former Imperial Theater, has been keeping since 1912. I stress, since 1912. So the first staging of that opera in the territory of the Russian Federation took place in 1913. We are exporting those materials, but we would like to ensure ourselves, and we export copies, not the originals of those notes. And we are never allowed to export a single original. And according to the customary law, the orchestra that plays the music, it's our orchestra pays for the lease of the notes. It's not about IP, because the receiving party, they are guided by the respective title holders, and then there was a claim, and it's not about some serious amounts involved. It's not about that. It's not about the seizure of notes, but still the problem arose. They demanded a lease payment for the use of those notes. Amounts were not very high, and it's not about money. It's about the cultural component or even ethical component of the matter. And it took me long to think it over, and I came to the conclusion that I didn't write the respective letter to the receiving party, to the short publishing house. And I wrote that since notes had been kept quite legitimately by the theater since 1912, and we have the embossment on those notes for the Imperial Theater. It's our property, and Germany recognized the Soviet Republic without any restitutional claims. It became our property, so we are traveling with the notes that belong to us. And even during the war, during the blockade of the city, we kept those notes. So we said that even if you try to find 50 euros from us, we will not pay you a penny. So that problem arose, and it brings about a number of questions about the. I'm not talking about art, but even literature, musical works that were created during the Soviet time by the order of the Soviet government. So the issue of definitions is quite acute for us too. So I would like to thank Mikhail Borisovich once again that you raised that point, and you looked at that from the legal perspective. I'm not going to criticize the Ministry of Culture, because they also have some constraints, and I don't think to have a situation when we criticize them and they try to justify themselves, or the opposite. The only underlying conclusion is that we have to meet more frequently, and we have to use any event of that kind to discuss those things. And to my regret, I has never been invited to be part of any working group, and my counterpart from the Bolshoi Theater has the same opinion. Thank you very much. It's understood. Well, time is up. So I would like to thank all the participants, and now we can see that there is a lot of room for improvement for us ahead. But we have some practical conclusions. First, global world, global cultures, different types of law, we have to merge. The point was made at the plenary yesterday, and we have to bring Russia closer to the world, but responsibility is to be shared. We have to enjoy same responsibility, have the same rights. We need to have guarantees that everything is done correctly, that icons will not stay for 50 years at some other place, as well as the canvas will not stay in New York City. We don't have our own laws, and we're always confident that we can give a guarantee to any museum, highest guarantee, and Minister of Culture and Prime Minister may sign such a guarantee, but we don't have any law. It's the opposite in the United States. They don't say anything, they say their laws are good. As for insurance situation, and we will really keep on asking for state guarantees, because in this country otherwise we will have just 3 or 4 exhibitions, and we depend on sponsors. There is one more point that I think is very important. It's terminology. Terminology is quite ambiguous and unclear, and we have a lot of codifications, budget codification, customs codification, which do not feature our terminology at all. And for the customs, they keep on talking about consumer goods, commodities, and application of commercial law or non-commercial law. There are also some pitfalls, and in fact, somebody keeps on trying to get us involved into an art market, but we're not the market. Certainly, a market is market, and there are prices, there are taxes. In our case, we are to be free from that. And I'm not a lawyer, and although we have discussed a lot of legal things here at the legal forum, but I would say that apart from law, there are a lot of other things, and if law is being executed or not. And a good point was made that sometimes a U.S. court may follow the State Department's line, in other cases not, and it's the case about the Schneerson Library, since there are some rumors that since Hasidim issues are involved, political views may be disregarded. So I'm really proud that the international law is applied now, and thanks to the museum community effort, and the latest example with the UK, and we have our counterparts from the UK, and during the holidays we prepared the meeting, and law was passed, and so we also participate. We should get involved with the judiciary too. And that court proceeding in Paris, I attended that proceedings, and our diplomats helped us to hire a lawyer, but they didn't attend the court's hearing, as well as in Washington. Now, for 2 years that we have not had any exchanges, we spoke to the U.S. counterpart, and we saw a number of good initiatives, and many people are indifferent to that. So I hope that we'll find a lot of helpful solutions for culture to prosper, but not to meet some selfish interests of various groups of people. And we have a specific task, that's the protection of the cultural property during the peacetime, and probably we'll have to keep working on that. I would like to thank all the participants for most interesting presentations, and I would like to thank our interpreters for their contribution. Okay, so let us meet more frequently.